Kuzeni, thank you so much for your time. Now, the court has found that he is the undisputed successor to the AmaZulu throne. Does this pave the way for his coronation?
Definitely it does, especially when it comes to the people that needs to do the last signing. In this case, the president and also the premier of KwaZulu-Natal. They have been thrown in the clear. Basically, the court was saying, go on and sign and go on and proceed with the coronation proceedings and the events that follow after that.
Now, we also now are seeing reports this afternoon that are suggesting that a statement has been issued and it says that the cases and the judgments that have been handed down today have no bearing on the matter of the successor to the Zulu king. They also say that there are some rituals that still need to be performed. These include ukukhuphula isilo, ukugeza izigodlo, nokugeza isihlalo. Now, they say that until such time that the core Zulu royal family members as well as the Royal Council have had their sitting to appoint a new king, it's also clear that those who respect the tradition and the culture must honor the fact that these things having not been done mean that there is no king on the AmaZulu throne. I wonder, what are your thoughts at this statement that we are now seeing according to some reports? Does it not go against the judgment that was handed down?
Not necessarily. Just remember that the judgment only concentrates on the procedures that have to be followed in order for a king to occupy the particular throne. And according to the judgment, it merely said that yes, a meeting was held of the Zulu royal family. Yes, there's a particular name that was nominated undisputedly, and it was nominated as being the name which is going to take over the throne of the Zulu nation. All that is required is the part 2 of the coronation, or the certification of the person who is nominated as king. So the internal sort of rituals that have to be performed are rituals which are only limited to the Zulu royal family, and they would have no bearing whatsoever in the events that would follow after that. Let's remember that it would be unheard of to have a seat of a king which is unoccupied, because at the end of the day, that means that you don't have a leader when it comes to that particular nation. So what has happened is that yes, a nominated individual has been chosen. His name has been sent off to the president for certification. And all that is required is that once a year has passed on and once those rituals have been performed, then the ceremony to officially nominate or officially coronate him and name him as the official king will then follow. But it has no bearing whatsoever in terms of all the other rituals that have to be there. And it has no bearing whatsoever on the legal status of the king as it stands at the moment.
So could we see an appeal to today's ruling, and what are the chances of its success?
Definitely we can see an appeal depending on how they want to look at the matters and the way in which the court pronounced on the matter. Let's remember that it was not before the court as to whether the processes of nominating and the king and coronating the king was a process which was done correctly. So the court was not asked to do that, but in its orbital ruling, which is a ruling that says, yes, it is of public interest that I have pronounced on a particular issue, and yes, there have been submissions that have been made either on paper or verbally by the legal practitioners once they were making their submissions. So I deem it important that I deal with this particular expert, because it may come back at the end of the day. So they may want to challenge the manner and the factors which were looked at by the court, either saying they're not important at all, or the court misdirected themselves in terms of determining those particular points. On those bases, then they would say, let's go on an appeal. We believe that a different court with a different set of judges will come to a different conclusion, taking into account all the other stuff that will bring into the fore. But let's also remember that at the end of the day, if you want to lodge an appeal, you are bound by the 4 words of the particular appeal. So you cannot bring in new evidence. You are only limited to the affidavits that you submitted earlier. You are only also limited to the legal submissions that you have made earlier. So anything that you do after that, you simply try and explain to a second set of judges that these are the mistakes that the previous judge probably made, and you beg them to come to a different conclusion.
And one of the things that was also, of course, ventilated in court is that there was also that issue of the interdict that was preventing the execution of, the late king's will, and also the distribution of assets among, his wives as well as his children. And of course that, this relates to that case of the authenticity of the will, as they now are looking for those handwriting experts that could then come in here. And the court saying that the succession issue has nothing to do with the will, and saying that because he, of course, named Queen Mantfombi as the regent, of course, as the great wife. I wonder if these particular developments could be used by others as, to further try and delay or even complicate this particular process of coronation. Could we see, that even being granted here, not even in the courts, but within the family itself?
I don't think so, because what the court was able to do was to distinguish between the two in terms of saying, yes, there may be a name suggested or nominated through a will. However, it does not mean that that particular will determine who the next king is going to be. At the end of the day, we go back to the KZN and Traditional Leaders Act, which was passed in 2019. And it says, and passes the ball or places the whole decision-making process on the Zulu royal family. So let's look at that process. If nomination through a will is not within that process as per the Act or per the custom of the Zulu royal family, then you can't bring it in. It may be that in this particular case, the wishes of Umntana Nkosi were then sort of projected through a will, which is something which is not against the law, by the way. However, it does not mean that it was a dictatorship type of pronouncement. It does not mean that there were no other individuals that could have been nominated. If you look further, and if we quote verbatim the words of Judge Madondo, he even said that Queen Mantfombi understood that at the end of the day, all that she was doing was making a nomination. In that, she even went further and said, in the event that I, the nominated individual or person that I've nominated, does not want to accept, I then bring it to the attention of the Zulu royal family that I'd like that person to come from this particular family. Meaning she well and understood the importance of the independence of the Zulu royal family. She well and understood the importance of them making that particular decision, and also knowing that the decision does not lie solely with her. With that being said, then it passed the ball over to the Zulu royal family to determine that particular fact. That's very important, because at the end of the day, the judge was very particular in saying that the very same people that are disputing the contents of the meeting and how the meeting went about did not attend the meeting. Now, it begs the question, how can you dispute such when you were not part of a particular meeting? It basically means that you are relying on hearsay evidence. It's something that the court can't consider and can't entertain.
As a final question, very briefly, someone watching tonight wondering how the process then of, the second part is going to unfold, especially when you look at, the hearing of oral evidence from handwriting experts. Talk to us briefly about what can we expect from those proceedings.
Let's remember the 15 days that have been allocated, in which they will then issue the summons in this case, because evidence will have to be led. And they would then name the various disputes or experts of the will which is being disputed. Then the matter would be set down with the other party being given an opportunity to come and dispute and state their side. And what is basically required is a trial in which the expert witnesses would go to the witness box, be able to prove and come to the methodology that they've used to determine whether the signature was authentic or not, and any other evidence that would be there. If the 15 days lapses without any submissions or any legal submissions or any launch of any legal proceedings, then let's remember that the will would now be certified as being authentic.
All right, it'll be interesting to see if anything happens within the 15 days, KZN, that has been, of course, declared by the court, and even how this is going to go in terms of those handwriting experts that now need to be brought in order to declare the validity of this particular will. That was legal analyst and MD of Zikalala Attorneys, Mpumelelo Zikalala.